much, Scott. Thank you for the organizers. I'm very pleased to be here. As much as I've worked with the statute over the last decade, and as much as I've worked with the rule set now over the last number of months, I still managed to learn an awful lot. And this conference in particular, I thought, was of the highest caliber. So to the organizers, let me applaud you. I really learned a lot here, and I hope that it's made available to others. A quick plug before I start off. I'm here today among, well, you invited me, but also with the indulgence of my board of directors at the AIPLA. And so I'd like to put a brief plug in for them. We've got a nice brochure out there too. We've amended our rules fairly recently to allow for non-US members, international members, and we think we're a pretty good bargain, particularly when there's still a lot more to learn about how AIA plays out, how the commentary on the AIA will play out, and many people have found membership in the AIPLA be valuable at this particular period of time. So I'd urge you to look into it. I've been asked to talk about harmonization and the AIA, and I'm going to talk a little more, even more broadly than that, about potential global harmonization on substantive patent law generally. Let me start a little bit with a little bit of history. And there's actually some people in the room who know it as well or better than I do. When I first came into the office in 1997, this was still a pretty hot topic. We were in the mid-90s of a whole series of treaties that were negotiated. A couple of copyright treaties, a trademark treaty, we had the patent law treaty around the procedural aspects of patent law. And so the idea of working together internationally and harmonizing was a very real thing. Of course, the thing that was the challenge at the moment, at that point, on substantive patent law was the relatively checkered history we had from the 60s on forward of being able to actually move the ball very far forward on the substantive issues. One notable instance here, the 1991 diplomatic conference collapsing again over the U.S.'s difficulty in many ways in terms of meeting the issue of first to file head on. I think now 11 years on, I'm sorry, 20 years on, gosh, 20 years on, it's interesting to see how we have come forward. But that was an early effort that failed in global harmonization. In the mid-90s, we had obviously the TRIPS came along, and it's a number of aspects of TRIPS are harmonizing, don't forget. The U.S., in order to meet the TRIPS obligations, for example, changed their term from a 17-year fixed term to 20 years for filing, and some other things. So TRIPS had its own good effect, particularly also, hopefully, bringing through the trade regime, bringing a number of the smaller countries on board the value of intellectual property in their own economic development. Many have questioned it since, some with reason, but at the moment, at that time, it was I think, an appropriate exercise. As I mentioned the PLT, we did do procedural harmonization. I think the U.S. has finally ratified the PLT, if I'm not mistaken, but that's still a fairly long time coming. But it was another big step forward. Then we got to the issue of substantive patent law harmonization, SPL, the so-called Substantive Patent Law Treaty SPILT, depending on your preference. Around 2000, 2001, when I was commissioner, and some of my colleagues in the other offices were approached about, did we want to make another stab at doing substantive patent law harmonization? We've got these other treaties done, why don't we go for the big one? And there was a general agreement that we should do that. And the context in which we were going to do it was the context in which we did the others, was through our friends at the WIPO. They have often served as the forum by which these treaties get negotiated. Once the treaties are in place, they administer them. They serve as the convener of the meetings of whatever union happens to be a function of that treaty. And so it was sort of natural to have WIPO get involved at their standing committee on patents. And so for the first few years in the 2000s, the standing committee met twice a year and attempted to move things forward. One of the key issues was what were the issues that we were going to address in substantive harmonization. There was an early discussion, a lot of discussion about so-called deep harmonization. Would it get down into substantive patentability, for example? Would it get down below a number of the sort of more important, but seem to be somewhat at the surface type issues. That proved to be too challenging. The next attempt, and I'm short-circuiting a lot of this debate, but the next attempt was then to say, well, what can we agree on as things we might be able to agree on? And that led to what was sometimes called the mini basket of issues. At its most terse, it was these 4 issues that you see here. First to file, the grace period, the definition of prior art, and how to deal with secret prior art. So the discussions began. Around the same time, maybe I guess a little earlier, the United Nations, however, required that all of its member agencies develop what is called a development agenda. An agenda for how the work that they do affects the developing nations of the world. And the developing nations that work with WIPO realized that applied to them too, and they started to bring that discussion of what did it mean to have a world IP system and substantive harmonization of patent laws to me as a developing country. What do I get out of it? And here's what I want to see from it. A big challenge in the early days was just things like definitions and the education of delegates and members to what all of patent law was about, quite candidly. And the upshot, in a nutshell, was that the negotiations severely bogged down. They bogged down to the point where in the mid-90s, eventually, they just stopped convening the standing committee meetings. And that was obviously a very low point in this whole discussion. But the whole issue is still obviously important. And so another attempt was made in the late 2000s, mid-late 2000s, when Director John Dudas from the USPTO and others from some of the so-called Group B+ countries, developed countries, said, well, maybe we should go outside of WIPO. Maybe we should come up with a mechanism on our own that would allow us to get to greater harmonization. So in what was called the Alexandria Process, because they formed it with the Alexandria Group, because it was originally met in Alexandria, Virginia, where the USPTO is located, those discussions started up too. And the framework was put in place, and formalities were put in place, and a leader from Denmark was put in place, and the Group B+ leader at the time was Mary Carmen from Canada. An interesting thing happened. There proved to be, among that group, a rather healthy skepticism around the rules too. I remember one time in particular when I was in industry at that point. I used to be the chief IP counsel for GE, and Mary and Dudas convened us and said, what does industry want in the United States? We said, we want harmonization. And she said, no, what do you really want? We said, we want harmonization. No, come on, don't hold back. What do you really want? We want harmonization. The message never quite, unfortunately, got through at that point either, if I could be so colloquial. I see people in the room who were associated with that process, and I'm spinning it a little, but that's generally what happened. So that was the sort of the history of harmonization up to a fairly recent time. There are other aspects, though, of harmonization. It's not only happening in these sort of multilateral fora, the big picture kind of places. It happens in other places, too, interestingly enough. One that it's mentioned not a lot, but is important to remember, is the U.S. so-called free trade agreements. The U.S. has, over the last number of years, continued to engage in bilateral negotiations on what are called free trade agreements. The cornerstone big one was called NAFTA, which is a North American free trade agreement, Canada, the US, and Mexico. But a whole series of these so-called independent free trade agreements have arisen up. The most recent ones was 3 of them, the most important being in South Korea, but also Colombia and Panama. There have been key provisions of intellectual property that have been written into these bilateral agreements, where the bilateral partners have agreed to maintain IP systems, particularly patent systems, that meet certain standards and include certain provisions. Many of these provisions are ones which we would consider harmonization issues. Broadened, and some of them very advanced. Sometimes it goes by the nickname TRIPS Plus, more than what even TRIPS requires. Broadened patentable subject matter is in some of them. Limited revocation grounds is in some of the others. Only, for example, only whatever you could originally not granted on or inequitable conduct. Patent term extension got written into a number of them. The grace year period, the full 1-year grace period, got written into some, with the exception of Singapore. Best mode, for some reason, we even got written into a few of them, as well as some aspects of 101. So there are, again, a number of agreements to which the U.S. and a number of major countries are being bound, which will include what we would call some of the issues that have been involved in the harmonization context. Another area that got touched on this week as well, where you could make the case it's a bit of a harmonization, is in PPH. When we've had the multilateral and bilateral, we had the bilateral, we never quite got to multilateral yet, but we've had the bilateral PPH agreements. Those obviously are, at least bilaterally, harmonized in certain ways. If we ever get to the multilateral version, the so-called pluripotent PPH, plurilateral PPH, there may even be more. But let me come back now to the AIA and what that has meant for harmonization. Now, it was clearly recognized when we were doing the AIA that one of the reasons for doing it was to basically do some kinds of harmonization, to bring the US system into what might be either considered international norms or into what might be best practices. That, for many of us, was a key driver in the AIA. That said, politically, in the United States, it was also a key problem. There were many in the United States, for many different reasons, but who felt that the United States has had the best patent system on earth for over 200 years, and that there is absolutely no reason for the US to change its patent system because it's the best, and it's proven to be the best, and because we're the most technologically advanced country on earth. It demonstrates the worth of the system, and our founding fathers wrote it, so why change? And we don't care if we're the last country on earth after the Philippines to have First Amendment file. The rest of the world should come back and go back to First Amendment. That is not, I'm a little bit tongue-in-cheek, but it was a genuine issue, to the extent that you had to be very careful in the debate over AIA where you brought up harmonization, where you stressed it as an advantage, because in some quarters it was seen as a reason not to harmonize and was used as an impediment. Here's several places and several examples where that was the case. First Amendment file in the grace period in the United States, change that, are you kidding? That's bedrock principle, said SMEs and independent inventors. Those are very potent, politically potent, or they were thought to be, very politically potent groups who held this for a long time, who defeated several versions of it over the years on just that issue. Prior user rights, talked about those a lot, you all are used to them. That is brand new in many ways to the United States. The little limited business method exception, that never got much play. But while being discussed for a long time, having it in the law is a very interesting thing. Universities, in particular, were apoplectic. Some in the University of Wisconsin and others to the nth degree, where they had their members of Congress basically lie down on the railroad tracks. Those are some of the places where there were actual major votes on these issues around prior user rights. Universities don't manufacture anything. They only license things, so there is no advantage to a system that allows a manufacturer who's been practicing a trade secret to suddenly pop up and say, when the university comes knocking and says, I'd like you to license my technology, and they say, we've been doing this for a long time, thanks very much, we have a prior user right. That is not to the university's advantage. Even, and this is a little bit of how cynical law gets made, as the speaker must have noted, there's a huge carve-out for the universities in the prior user rights. That was a pure political matter. It still didn't, it split the university community enough that it allowed it to go forward politically, but there was still plenty who did not like it. Also, the fact that you're not harmonized on prior user rights in Europe was something of a factor as well. PGR and the opposition system. A lot of major arguments against why should we move to an opposition system in Europe. Europe doesn't do such a great job with it. It takes too long, it costs too much. The PTO can't handle it. Judges aren't up to it. It's priced too high. It's too easy to get into. They're going to abuse it. We're going to have opposition trolls. A lot of very strong arguments against that particular provision as well. That said, obviously the act passed. That's what we've been talking about. It passed fairly handily, interestingly enough, as a political matter. And harmonization, actually, at the end of the day, got into the act. If you'll pardon the expression. And here it is. We have something in our law called the sense of the Congress. They're usually sort of thought of as fluffy afterthoughts that get added in to feel good or to give somebody a political shit. Not completely. They actually, there is case law that says they actually have some effect, some literal legal effect. And they certainly have a moral effect, if you will, that you could point to later saying, hey, the Congress passed this, as they did. And here you see it, I've written it out in its entirety. It's the sense of the Congress that converting the U.S. patent system from first to invent to a system of first owner and file will improve the U.S. patent system and promote harmonization of the U.S. patent system with systems common in nearly all other countries throughout the world, with whom the U.S. conducts trade, and thereby conduct greater international uniformity and certainty in the procedures. So harmonization as a topic, as an issue, as a concept, is embodied now in this statute, and it'll be very interesting to see how that gets used going forward. What was the goal in global harmonization? I'm going to talk a little about where we find ourselves now as a function of the AIA. Well, first of all, I think it's widely recognized that the goal for harmonization, if we have a very broad goal, is to identify, to recognize best practices through various mechanisms, not least of which is negotiation or a series of analytical tools, but to identify the best practices that we can find and to implement them. There's a corollary here. There will have to be changes made everywhere as we find that nobody has the complete set of best practices. So if we ever move to global harmonization, or we move to the negotiation of it, as I sometimes like to say, it's not a matter of the U.S. becoming a member of the EPC. No, there are changes that are going to have to be made in Europe, they're going to have to be made in the United States some more, they're going to have to be made in Japan and in China and Korea as we identify what the best practices are. And we need to be preparing ourselves for that fact. What literal current harmonization efforts in the last few years, particularly during the Kapos administration, have occurred? First of all, fairly recently, Director Kapos identified an opportunity. The U.S. was the head of, was the president, I guess is the technical term, for 2011 of APEC, the Asia Pacific Economic Council, Coordination Council, I think it is. And so Director Kapos chose to use that forum of Asian nations, any nations ringing Pacific Rim, includes Canada, includes Australia, and most of the Asian countries, but it also includes the U.S., Chile, into a meeting called the Asia Pacific Patent Cooperation Conference. It took place in March of 2011, and Director Kapos gave a speech to open that up. The basic thrust of which, or the title of which, was called Taking Up the Charge for Patent Harmonization. So this administration, the Kapos administration, firmly wanted to put the issue of substantive patent harmonization globally back on the table. And he, I think, purposely went to Asia because in some ways, a lot of the debate and discussion has always sort of been between Europe and the United States. And I think he may have seen a fresh opportunity by starting off with Asian countries who didn't have quite so much controversy, maybe not quite so much skin in the game, but had an opportunity for a fresh, new view. What were some of his, you can read his remarks, I was going to quote from some of them, but some of his rationale are listed here in these bullet points. Our economies are driven more and more by innovation. That should go without saying, but it doesn't mind repeating once in a while. Obviously, the varying laws that we have among the countries, the various systems, cause enormous rework, enormous redundancy, and waste billions of, it's been identified clearly as wasting billions and billions of dollars. So harmonization has a real economic impact, not only in terms of what doesn't get done, but what gets expended in trying to overcome the negative aspects of harmonization. So in his view, and I think he represents the administration, harmonization is an economic imperative. It has to be global in scope, even though he was talking primarily to Asian countries. He realizes it has to be global in scope, and that we need to develop, if we don't have it, we have to come together, figure out how to get the political will to move forward. Because I think one of the key obstacles, frankly, as a person who's worked in it a long time, is there just isn't seen as having the political will. One good example, the AIA. I think for a long, long time there was a belief that the United States would never change, we'd never get first inventor to file across, that while if we didn't get first inventor to file across, there's no reason to put the political will and to go higher up in our political organizations to develop that will. But now having, at this point he was foreseeing that we passed first inventor to file, and now having passed it, that is a game changer. And that I think creates an opportunity, that I mentioned, for developing that political will. The next step that he undertook was outreach to Europe. There was, I think, some concern about why was this secret meeting being held in Washington where the Europeans weren't invited, though they technically were invited. I think the EPO did have a rep there, I think so, yes. But there was a concern that maybe, hey, wait a second, don't overlook us. So Director Kapos came here to Europe, visited with one of the national offices in particular, where he found a very receptive audience. I think it's, in his view, I think, if I can paraphrase, it's surprisingly receptive, and he also went and talked with his peers at the EPO. Now, the EPO always has a bit of a challenge in harmonization issues because, as they like to say, they don't have competence in it. They don't have policy responsibilities. They're merely a factory that does all this great work, but they do, and they're important, and we have to make sure they're included in the discussion. But where this led was something called the Tegernsee process. And I'm not familiar with all the ins and outs of it, and others may have, but what he did was convene a number of these representatives of a number of these offices, as well as, I believe, the EPO, at a lake called Tegernsee, which I think is here in Germany. So, yes? Did I spell it wrong?
Sorry, when you say he, you are speaking of the president of the EPO.
I will back up a step. That is true. I should stick to the politics of it. I think that it was decided that the president of the EPO would convene the Tegernsee group at Lake Tegernsee, nearby here somewhere. And indeed, President Battistelli served as the official convener of the Tegernsee group. I am probably giving Mr. Kapos a little more formal responsibility than he had in this process. But the EPO president convened the group. It was primarily members of the European offices as well as the EPO and the US. I guess Japan was present. I think some of the other Group B+ countries were present. And they came, I think it is called the Tegernsee Experts Group. Their charge, at least at the early stages, was to identify key areas for harmonization, to prepare comparative studies, especially among the three major systems, the US, Europe, and Japan. And that process is now in place and ongoing. A next step on the edge of that is that the so-called industry trilateral, the trilateral being the three major offices, there are user groups. We are one, the IPO and the S is one, JIPA is one for Japan, and Business Europe is the representative of Europe at the industry trilateral. They have also taken this up for study, and we'll meet in Japan next week, as a matter of fact, and this is on our agenda, using the Tegernsee study as a model. How does this relate to the AIA? Well, in many ways, the AIA provides the framework for these harmonization discussions. The key issues, a lot of the key issues that are in the AIA and addressed by the AIA are ones which are right at the forefront of the Tegernsee study process and the harmonization effort. First inventor to file and grace period, key among them. Though we are now told we're not supposed to call it grace period, we're supposed to call it non-prejudicial prior art, NPPA. So we'll try to keep doing that. The AIA has almost eliminated the best mode. Did eliminate the Hilmer Doctrine, two key stumbling blocks in the past in the US system to harmonization. It did by and large, retain secret prior art, but that's an issue that's then on the table, I think, for the harmonization discussions. It puts a lot of pressure, I think, on pre-grant publication. One of the issues which Europe continues to identify is the fact that the US, theoretically, does not have complete 18-month publication. We have a provision that you can opt out if you agree not to file outside the United States. Something like 4% or 5% do it. The uncertainty of it is seen as the issue. Director Kapos has said repeatedly that if that's a roadblock to harmonization, let me add it. What I will do is take all of those cases out of turn, and we will have all those applications examined by 18 months so that they will issue and be prior art. Forget about publication. They will issue or not issue and be prior art before that 18-month deadline. So there will not be a gap or a secret body of prior art, which is likely to cause a problem. But more importantly, personal opinion. What the AIA did, getting it passed when lots of folks said we would never get it passed, and I plenty of times I didn't think we'd get it passed, was that it truly, I believe at this point, alters the political and the policy dynamic around the issue of global harmonization. It starts the unthinkable can start to be thought. One good example. We would never get to, in many of the places where we talk about this, and many of the trilateral, the EPO meetings and everything, we would really never talk about the grace period too much. For example, we would just say, we're not getting the grace period until we get first to file, you're not going to be first to file, case closed. Now, what we're talking about is types of grace period. the Korean grace period, the fact that, as Dave said yesterday, Europe does have a grace period. It's a 19th century grace period, key to World's Fair disclosures, but you have a grace period. What we need to do is talk about the grace period and see how we can get to a compromised place. He said things yesterday which gave me a slight bit of a frisson, when he says declarations may be on the table, that sort of thing. We have great friends here in Europe like Heinz Bardelli, who's been working on this issue for years, who I hope will be able to see this movement that we're talking about. I think we'll see it. And so it's a fundamental shift, I think, to be talking about the philosophy and whether or not you can talk about it, to actually be talking about it. And I think we're starting to see that now. What are we talking about? These are the topics that basically come out of things and other things. These are the topics that are being discussed. Entitlement is the concept in Europe. We don't really have it in the United States. Inventorship, I guess, comes as close as it might come. What do you do with one issue is what do you do with conflicting applications? Well, basically first to file, but there are some exceptions that have to be dealt with. Challenges and remedies to inventorship. We have this new derivation process, which you've heard about the last couple of days. For example, is that something that has to be imported into a harmonized regime? Novelty and prior art. Public disclosures, what constitutes a public disclosure, is obviously, as you've heard, a matter of no small dispute. You've heard reference to the so-called colloquy among several senior senators on the floor. It'll be a number of years before that's fully defined in the U.S. But then there are the exceptions to that, non-prejudicial disclosures, if you will. The grace period, is it meant to be a safety net alone? Should it just be the inventor's own art, which serves as the gracing document? Do they have to file a declaration? When do they have to file the declaration? How broad does that declaration have to be? As you see down there in the bullet near the bottom, what's the estoppel effect of that declaration? A lot of those kind of issues have to be thrashed out. Public disclosure versus publicly known. Again, those two have to be reconciled. And we still have to wrestle the question of secret prior art to the ground, whereas unpublished applications in the U.S. by and large are prior art and are not other places. That has to be decided. Inventive step and non-obviousness. Here it's the same for novelty except for secret prior art. United States, it's the same for novelty. How you use the methodology obviously differs in terms of how you find non-obviousness in the United States and how you find inventive step in Europe. There is a methodology difference. That has to be presumably reconciled. Prior user rights, as I said, those are nationally based by and large, particularly here in Europe. It's a defense. It's not a right, I guess. It's a defense, and so you still have to harmonize in many ways. We would have to harmonize. If you could put, and I've seen the charts, and some of them I think had them, you could put all the prior user right aspects up one against the other, and so the challenge will be to figure out what's the best practice within those. The AIA, for the first time, indeed, does have prior user rights. As I said, they're new and very limited. They're very limited because of that political pressure from the universities. There is that big carve-out that stands out relative sore thumb in the prior user rights. There's issues of transferability, all those kinds of issues. And finally, 18-month publication. I mentioned our opt-out provision. There's also the questions of post-publication, what rights attach to the publishing entity, to the applicant, once the publication occurs. In the United States, for example, you have a certain limited right to go after an infringer, as long as one claim that you've originally filed eventually issues in that form, that sort of thing. That issue of what rights attach has to be decided too. So as I said, I think the AIA, in sort of summary, the AIA significantly facilitated, in many cases somewhat surprisingly, the potential advance on harmonization. We are having the discussions now. The Tegenzi process moves forward. The trilateral process moves forward. I had one of our committees visit with the EPO 3 weeks ago, and they gave us a wonderful presentation on what they would, in some of these issues, and what they would hope to see in the debate. And this has caused, as I said, a changed international dynamic. People's positions are now starting to change, or at least they're opening up. The players that are involved in the debate are changing in many ways. The political will question I've already mentioned, and how to develop that political will is going to be critical. The role of the EPO again, as convener, but also as competence, non-competence is a key question, but they are key to this whole process. Will there be other priorities that may get in the way? There's always something that might stumble this. If your focus in Europe, for example, turns to the community patent, or our focus goes too much towards how to implement the AIA, which is a huge amount of law and legal process to swallow all at once, that may cause this to slow up a little bit. There are changing regimes. If the President of the United States changes in next January, the director of the USPTO will very likely change too. Will that change the U.S. priorities around harmonization? Don't know. But I have to say, if I had to summarize as somebody who's been at this nearly 20 years, and pretty involved in it at a very senior level, I think, for me, hopefully not too Pollyannish, it's looking better than it's looked in a very long time. I'm hopeful that we can move the ball forward on it, both short-term and long-term. I would hope, personal view, not my organization, but maybe the time has even come for folks to craft an initial draft of what a treaty might look like, all full of brackets and options and that sort of thing. But the time, I think, may come for someone to put that draft out there and to start the process for discussing how to deal with that draft. Bottom line, as we say in the United States, stay tuned. Thank you very much.